Good morning, everyone, and thank you so much for joining us today for our monthly webinar series. Our March topic, we're going to be talking about inherited retirement accounts like IRAs, 401ks, and third-party special needs trusts. Today's presentation is presented by myself from NYSARC Trust Services, Sarah Grimes, and I'm very excited to also have a member of KeyBank's team with us, Cindy McDonald, is joining me today. She's going to chat with us a little bit about the intersection between retirement accounts and third-party trusts and some new legislation that has impacted the planning for leaving retirement accounts to a loved one with a disability. Now, up to this point, all of our programs have really been focused on a person who receives Medicaid or SSI benefits, who has money in their own name that they need to protect in order to qualify or maintain financial eligibility for services. And today we're going to be switching gears and focusing on how you, as a family member, a parent, a grandparent, or other loved one, and even an organization, entity, or service provider can leave funds to an individual who receives Medicaid or SSI benefits, or who may need those benefits in the future, in a way that it's not going to impact their financial eligibility to qualify or maintain eligibility for those programs. Before we jump in, just a reminder to everyone, you are all muted and chat is disabled just to limit some background noise. You can chat with our hosts and panelists if you have specific questions. And we do ask that you put any sort of questions for the presenters into that Q&A section. We will be reviewing those throughout the presentation and we'll be saving those for the end. We'll leave about 15 minutes where we can go through any questions. Closed captioning has been enabled. So if you're on a desktop device, you can go ahead and turn that on. You do need to do that on your end. It's not automatic. And the materials will be sent in a follow-up email after the training. Nina is also going to drop a link to those in the chat now if you'd like to take the time to download those so you have them. The Zoom settings don't allow us to email any sooner than the day after the training. So if you want to make sure you have copies today, go ahead and click that link from the chat. We are recording today's session, and it will be available at nysarctrustservices.org on our webinars page at the link here on the screen. You'll also receive a link to that in the follow-up email from tomorrow. So as we know, individuals who receive Medicaid or supplemental security income benefits, or who may need these benefits in the future, have pretty strict financial eligibility requirements that they need to adhere to in order to be eligible to receive services through these vital programs. A single individual receiving supplemental security income benefits can only have up to $2,000 in a bank account or in their name available to them and be financially eligible for that program. Now, supplemental security income benefits, for anyone on the call that may not be aware of this program, is a special type of Social Security benefit for individuals that have a disability who generally are not able to work. And it gives them a portion of money each month. The amount someone receives is going to be based on a person's individual situation to help fund services and supports that they need throughout their lifetime. But in order to access that wonderful benefit, they can never have more than $2,000 in their name. If you are not receiving SSI benefits, perhaps you're the individual you're considering setting up a trust for is only receiving Medicaid services, like through a waiver program or some sort of community-based Medicaid long-term care services benefit, they have a much higher resource limit. This year, particularly, it's almost doubled. Last year, it was about $16,000. Now it's up to $30,000 that a person can have if they only have Medicaid services. And one other important thing to note is that if you're considering planning for a child who may be under the age of 18, just know that there are different types of Medicaid benefits. And some Medicaid benefits don't have a resource test at all. So it's very important to know what type of benefits your loved one receives when you're trying to plan for their future. Now, one way to help a person protect their ongoing eligibility for these benefits would be to set up what is called a third-party supplemental needs trust. so that any assets or inheritance that you want to leave to your child or loved one can go into a protected vehicle that's not going to put those benefits in jeopardy. Now, this is a little bit different than the first party trust we've been talking about in our previous webinars, where it's the individual's own money going into the trust. This is a similar type of trust in that it's still an irrevocable supplemental needs trust, but the key difference is that this is funded by someone other than the beneficiary or the individual who is receiving the Medicaid or supplemental security income benefits. Just like the first party trust, it is still allowable under both federal and New York State statute. The beneficiary does need to have a qualifying disability under the Social Security Administration's definition in order to use this trust program. And this vehicle is primarily used to ensure that you can leave funds to them in a way that they will not impact their eligibility to qualify for benefits in the future or maintain their ongoing eligibility for those services if they were to come into a sum of money that could potentially kick them off benefits or reduce the benefits that they're receiving. Another added benefit to using a supplemental needs trust is that you have a trustee who's going to manage those assets on behalf of that beneficiary to ensure that those funds are used appropriately and wisely so that that money can last and are used for that beneficiary's primary benefit, that is used for things that are going to improve their quality of life. One of the most important benefits of establishing a third-party supplemental needs trust for your child or loved one is that there is no payback to Medicaid upon the death of the beneficiary. In a first-party trust, because it's the person's own money funding that trust, when that person dies, if there's funds left in the account, Medicaid generally wants to be paid back for the services that were provided to that person during their lifetime. With a third-party trust, since it's being funded by a donor who did not receive Medicaid services, there's no requirement to repay Medicaid. So we'll talk a little bit more about that when we discuss different options, but that's a great advantage of a third-party trust to ensure that any money that may be left can go to other family members or even perhaps a charity of your choice. Most third-party trusts are going to be funded upon the donor's death. Most people are going to set up the trust so that it receives the proceeds from their will or estate when that donor passes away. But you certainly do have the option to also establish a trust during your lifetime if you have funds now that you'd like to put into an account that your loved one can utilize while you are here. Just like first-party trusts, we have different options. You have a standalone special needs trust, which is a great option that provides a lot of flexibility to families, giving you a little bit more control and direction over the structure of that trust. And standalone special needs trusts, generally, depending on the trustee you're working with, can manage both cash-based assets and real property. With a pooled trust, this is slightly different. Same thing with the first party, where it's run by a nonprofit organization. So you don't need to select a trustee to manage the account. You have a trustee in place that's going to oversee the use of those funds. The documents are already in place, so you don't necessarily need to draft documents, but you will still need to work with an attorney to ensure that the trust is appropriately named in your estate plan. And most pooled trusts take cash-based assets only. Don't typically manage real property. However, you may be able to find a pooled trust program that does. That's something to be thinking about when you're considering what assets you may leave to your loved one. And it does not mean that we certainly do work with people who inherit real property, but they generally will receive the proceeds from the sale of that home, and those cash-based assets would go into the trust. We also want you to consider that in addition to special needs trusts, if your child was disabled prior to age 26, you also have the ability to take advantage of an ABLE account. These tools used together can really help maximize the benefits that a person can receive and give them more flexibility in the use of the funds and their access to those funds. So it can be beneficial to have your loved one have both a special needs trust, maybe even a first-party special needs trust and a third-party special needs trust and an ABLE account if they're able to. Forgive my pun there. All of these tools together can really give your loved one the most benefit because each of them have unique advantages. It's important to note that with the ABLE account, you can only put up to $17,000 a year for under New York state law. That is the most that you can contribute to an ABLE account in a single year. And that is from any source. So if your child wants to put their own money in and you want to put money in, both of your contributions, those are combined to meet that $17,000 a year maximum. And if the individual receives SSI services, any amount of money in their ABLE account that exceeds $100,000 will be counted as an available resource to them. So those are just important things to keep in mind. Also, we talked a little bit about that Medicaid payback provision. When you, as a parent or a loved one, leave funds to your child in a special needs trust, there's no payback to Medicaid. But when you put that money into an ABLE account, all those funds will be subject to Medicaid payback when your child is deceased. So if you are planning to put your own money into an ABLE account, just be sure that it's money that your loved one will be able to use during their lifetime. Otherwise, it will be subject to Medicaid payback. Some of the most common ways that people fund third-party trusts are generally, like I said, at death through the proceeds from their estate. We often hear from families that I don't have enough money to leave to my child. But as we spoke about earlier, a single person receiving SSI benefits, receiving an inheritance of even $2,000 could put them over that limit and cause a reduction in their services. So it could be proceeds from the sale of your home. It could be naming them as the residual beneficiary of your retirement accounts. Life insurance. Life insurance is usually one of the number one things that at least you have a life insurance policy that you may want to leave to a loved one or an annuity, for example. I also want to take a moment to just highlight the uniform gifts to minors accounts. Sometimes they're referred to as a UTMA, UGMA, depending on when that account was set up. This is a special type of bank account that allows you to essentially have funds set aside for your loved one that's not going to be considered available to them until they reach the age of maturity. And the age of maturity may be 18 or 21, depending on what state you're in, depending on how that account was set up. But the important thing to understand is that when they reach that age of majority, that money becomes their money. So if you have one of these accounts set up for your child in hopes that it will protect their eligibility for benefits, it will only do that until they receive that money. Once they have that money in their name, it would need to be put into a special needs trust in order for them to qualify or maintain eligibility for benefits. And that's generally the time when they're applying for those benefits at the age of 18 or the age of 21, when they're no longer, their financial assets are no longer being calculated based on your income as a parent. It's now based on their income. And so these are really important. If you do have one of these accounts, it would be a good idea to take a look at that, have a discussion with the beneficiary of that account, and talk about perhaps closing that out and moving those funds to a special needs trust in advance of them receiving that money. Otherwise, they will need to create their own trust for that, and that would be subject to Medicaid payback. Another common source of funding of these trusts may be from an actual trust. You may have set up some form of trust, and you want to ensure that that goes to a special needs trust for your child if they were to become disabled in the future and need these benefits. Now, I want to take a quick moment as we are talking today about retirement accounts specifically and some of the advantages of leaving retirement assets to your loved one through a special needs trust. Now, again, the important thing here is that you are naming the trust as the beneficiary of whatever portion of your retirement account that you would like your loved one to receive. If you leave the funds to them directly, they will have ownership of that money, and they will then still be able to protect benefits by creating their own first-party trust, but you don't have those advantages of the no Medicaid payback. And it's also important to note that we're not talking about dissolving your retirement account and putting a large lump sum of assets into a special needs trust. We're talking about the required minimum distributions that would be coming out of that retirement account for their benefit. And each time those distributions are made, they would go into a special needs trust for your loved one, rather than going to them directly, which could cause income issues, resource issues for their eligibility for benefits. Now, one of the advantages of this is because we recently had a legislative change regarding retirement accounts. Traditionally, we did not have to spend down a retirement account for any sort of set amount of time until very recently. If you leave a retirement asset to one of your children who does not have a disability, they'll be required to spend that down within a 10-year window. If you leave that to a child with a disability, however, they have the option to stretch that money throughout their lifetime. And there's obviously advantages to that. I don't want to get into too much detail because I don't want to steal Cindy's thunder. She's going to go into this in more detail a little bit later. But that is one of the benefits when you're considering what assets you may want to leave to what children. They do have that ability to stretch the retirement asset throughout their lifetime. Another recent change, one of the caveats to that was that you could take advantage of that extra stretch as long as the residual beneficiary of that trust was a person. Meaning an individual or another family member. They did not allow you to leave that money to a charity. And that recently changed with the most recent update to the Secure Act. So you are now able to name your favorite charity or nonprofit, service provider who has provided supports to your child throughout their lifetime, if you so choose to. And before we move on, I do just want to reiterate and highlight from some of our previous trainings that New York State is very unique when it comes to retirement accounts. Okay, so if you're listening from another state, this may be very different in your state. But in New York State, we consider a retirement account to be an exempt asset for Medicaid purposes, as long as you have it in payout status. So if you yourself have a retirement account and you have a catastrophic accident and an injury that leaves you disabled where you need to rely on Medicaid benefits, or simply you just apply for Medicaid as you get older and you have a need for home care services, know that this is one of your most protected assets. It will be exempt for Medicaid purposes as long as you are taking distributions from that account, and then it can pass to your loved ones upon your death. So it's just really important for everyone to know retirement accounts in New York State, we're very fortunate, are one of our most protected assets. And we do want to just remind everyone that anytime you are making decisions about retirement accounts or any sort of residual beneficiaries, there are legal and tax considerations, and we encourage you to work with a professional before making any changes to your residual beneficiaries. Now, I'm going to take some time to just go through some of the kind of key differences between the standalone special needs trust option and a third-party pooled trust option like the one we have at NYSARC, the third-party community trust. As I talked about a little bit earlier, some of the key differences is how you're going to set up that trust. So a standalone third-party trust can be created through your will or estate plan to be funded upon your death, or you can draft a trust document during your lifetime and you can put money into it now and have those funds available to your loved one. Either way, it requires an attorney to draft those necessary documents. And we encourage you to work with an attorney that specializes in this area, particularly someone with an elder law or special needs background. You want to make sure you're asking those questions because a lot of attorneys can draft trusts, but not quite as well when we're considering all of the different things that you need to be thinking about when you have a child with a disability. In this type of trust, once the documents are drafted, you are going to need to select someone to serve as the trustee of that trust. So someone who's going to manage the assets, someone who is willing and able to take on that role. And you may also need to think about appointing successor trustees. What happens if that trustee is not able to serve at some point in the future or chooses not to? You want to make sure you have backups. You're also going to need to decide how are the funds going to be invested. We want to ensure that this money can last as long as possible and provide the greatest benefit to our loved one throughout their lifetime. So investing the funds may be a good option depending on how much assets you have. And you want to be sure that you have someone who's either a trustee who's comfortable doing that, or perhaps hire someone to help provide that support. With a third-party community trust, which this is kind of modeled off of NYSARC's program, but this is going to be similar for most pooled trusts, the documents are already drafted. A legal document overseeing the trust already exists. So you're simply applying to join that program by filling out an application, which we call the joinder agreement. That's completed by the donor during their lifetime. They give us some supporting documents for the beneficiary, a copy of the beneficiary's Social Security card, and a copy of their Social Security award letter that helps us verify their benefits and have their information on file to establish the account. It does cost, you're going to incur an opening enrollment fee to join the program. Generally, each pool trust might be a little bit different. In our program, it's a one-time enrollment fee of $750. That's giving you access to our trust document and working with our team through the enrollment process. One of the benefits in this particular option is that you're getting a professional trustee. And when you compare it to the your other options of a financial institution or another professional trustee, they may only be willing to work with you if you have a large sum of assets. The pool trust has very low minimum funding requirements. So it really does make this accessible for a family who may only have a $30,000 or $50,000 life insurance policy that they want to leave to their loved one. You're also getting the added benefit of having a trustee in place, a nonprofit organization that has knowledge and experience with the government benefits, knows how to use the funds appropriately to give your loved one the best quality of life possible. And in our program, we have the benefit of KeyBank, who does the financial management of the assets in the trust. And KeyBank has 190 years of wealth management and fiduciary experience that they use to help us ensure that the funds in the trust can be there for our beneficiaries and provide them with the most benefit throughout their lifetime. Now, here's just a quick overview of the two third-party trust programs that NYSARC offers here through our program. Our third-party community trust is actually relatively new. This launched in 2021, January of 2021, and it's available to a person any type of disability as long as they meet the Social Security Administration's definition. As I mentioned, there's a low minimum funding requirement, so you only need $10,000 to open this account, and you don't need to fund it today. You can set up the account with a one-time enrollment fee, and it can be funded through the proceeds from your estate upon your death. If you choose to open it without the $10,000 minimum funding, you will simply incur a one-time a year $50 charge for the administrative work that NYSARC does throughout the year. We'll reach out to you once a year, we'll check in, we'll get updated contact information, gives you access to our online portal, allows you to communicate with our team anytime you have questions. If you want to update us throughout your loved one's lifetime about changes to their wants, needs, goals for the trust. We also charge monthly administrative fees. NYSARC is going to have a fee for the administration of the trust, us using the funds to help pay for expenses. And then there's also the investment management fees for KeyBank's portion of the work. And those are charged monthly based on the balance that's in the trust at the of the prior month. So relatively reasonable fees when you compare that to your other professional trustee options. And because this is a third-party trust and there's no requirement to repay Medicaid, you will name in the joinder agreement who you want to receive any money that may be in the account upon your loved one's death. You can name your other children, you can name grandchildren, whomever you'd like, and NYSARC will distribute the assets based on the directions of the donor in the joinder agreement. There will also be some closing costs of closing out the account, and all of those are detailed in our fee schedule on our website. The NYSARC Unrestricted Fund is actually our original trust program. This is the trust that we established in 1972. It was our very first trust. And so it's very true to our mission, and it is available to individuals with intellectual or developmental disabilities. So generally, if you have a child with an intellectual or developmental disability and you're choosing between these options, the unrestricted fund is generally going to be more advantageous to you and your family. It does require a $25,000 minimum opening deposit, but of course that can be funded through your estate upon your death. You do not have to come up with $25,000 today in order to create this account. Because it's not a pooled trust, it is a standalone trust. You do need to work with an attorney to draft a trust document and or include language in your will to establish this trust account. And we have an attorney on staff here that can work with your attorney to help them and provide them with sample language to work through that process. Our team does need to review and approve any sort of trust documents in order to create this program. Because this trust was established to really serve our mission and the population of people that we serve through the ARC New York, NYSARC charges no enrollment fee to open up this account, and we charge no administrative fees during the lifetime of the beneficiary. The only costs of the trust will be the monthly fees for KeyBank to do the investment management and any sort of specific costs related to activity on the account, which again are all detailed in the fee schedule, which you can find on our website. Because NYSARC does not charge any fees while the beneficiary is using the account, we do ask that the first $25,000 at death goes to NYSARC, and any remaining money will go to residual beneficiaries as named in the trust document. Of course, there are going to be times where maybe there is no money left in the account and there is nothing there to give. But if there is that potential that other people in your family would be able to get access to some of that money. Now, with that, I'm going to turn things over to Cindy, and we're going to switch kind of back to talking a little bit more about the retirement accounts and what exactly that looks like. What are the mechanics once you do leave a retirement account or name a trust for your loved one as the beneficiary of a retirement?
Great. Thanks so much, Sarah. That was wonderful. Really good information. So what I'd like to do is kind of touch base on the original Secure Act, what that looked like and how that panned out. And then we're going to talk about the changes, which I think are really good for the third parties trust that we can fund with these retirement assets. So going back a couple of years, the Secure Act came out, and what they wanted to do right out of the gate was eliminate what we call the stretch for an IRA. So before the Secure Act, mom and dad would be able to, within their IRAs, name their kids as the beneficiary. When they passed, the IRA assets would roll into an inherited IRA and benefit. And then what would happen is that IRA would stretch out for the lifetime of the child. It would make payments there. Their child would then name their child as a beneficiary. And this thing could just keep stretching. So what the Secure Act does, the first part, the Secure Act 1.0, we call it, is they eliminated the stretch for most individuals. So basically what they said is now you have, if mom has an IRA and she leaves and names her children as beneficiaries, there is a 10-year limit to which that IRA would have to pay out. So over the course of 10 years, the IRA would have to pay out, and that it would be gone at that point. There were exceptions, though, which are still in place, which thank goodness they are. And the most important exception, I think, here are for disabled or chronically ill individuals. So this helps in the planning aspect of it. So what does it really name when you name a special needs trust as an IRA beneficiary? So there's two types of trust, and I know that Sarah kind of touched on them, but I'm going to touch on them a little bit deeper here. And there's different terminologies, and that's why I have it listed out here. So you'll hear the term conduit and accumulation, and some people are like, well, what are you talking about? So basically, when you talk about a conduit trust, it's the first party trust. So it's those disabled individuals, their own assets that they've put into an irrevocable trust. People flip-flop terminology around. They call it a first party. They call it a self-funded. They call it a conduit trust. So we live in the world of like crazy acronyms, but for simplicity here, we're going to call it that conduit first party trust. So what would happen is if mom had an IRA and she named her son, daughter's first party trust as the beneficiary, what would happen here is that the RMD would actually be calculated and be deposited into that first party trust, but it doesn't stay there. It has to get paid out by the end of that taxable year because it's a conduit trust, it's a pass through. So it's not really effective for what mom and dad probably want to do. And we're here today to really talk about that third party and the fantastic benefits that are in place here when you establish a third party, particularly the pooled trust. So We call those third-party trusts, which we call them accumulation trusts because they accumulate assets. So third party established by mom and dad, grandma, grandpa, aunt, uncle, whomever, they create this pooled third party trust for the benefit of the disabled individual. And then they name that trust in the IRA designated beneficiary form. So it's like mom's IRA, the beneficiary would be Joe Smith's third party pooled special needs trust. So what would happen is when mom passes, then that becomes an inherited IRA that stays in that IRA wrapper. And now the measuring life is the disabled individual that's the beneficiary of that third party pooled trust. So now now it's stretched out to their lifetime, and those required minimum distributions are calculated annually. And just that part is then distributed into that third party special needs pooled trust where it can accumulate. It is not forced to pay out each year, which is great because you can accumulate those assets. And then if the individual happens to have a first party or a third party, where NYSERC, this is where it's really key because they are professionals. They understand this world very, very well. So they're going to know, okay, if a request come in to make payment on something, the first party trust is typically the one they're going to pay from first because that third party trust can accumulate. But if an individual only has the ability to mom and dad to create just that third party, then it's there. It's there to be used properly. And NYSERC, they are very well versed into what can and cannot be distributed from a trust like that. So you're really working with two sets of professionals here that really want to, the ultimate goal is to protect the assets and make them stretch as long as possible. So if we kind of jump to the next page, Nina, we're going to get into a little bit more just to reiterate about that third party because it's really important. It is a key planning tool for parents because if you think about it, the two biggest assets of mom and dad are their IRAs and their houses. So it's like, how do I get that from my estate plan into a protected vehicle, such as a third party special needs pooled trust for my disabled child, and then have, when the disabled child then deceases, pay out back to family members or to whomever they would like. So again, Secure Act 1.0, before all these changes came into play, they said you could really only, mom and dad, when you have your IRA, you can only name humans. So the third party special needs pooled trust is considered a human because when you look through, you're like, there's an actual human there. It's a beneficiary, the disabled child, and then maybe other siblings or whatnot. You could never include a charity as a remainder beneficiary. If they did in Secure Act 1.0, then it would be forced into that 10-year payout. So they kind of sat back and they said, that's not really helpful. Like you're really not benefiting all those not-for-profits that are standing by mom and dad throughout the years, helping them and guiding them on the support of their child throughout. And like mom and dad really want to leave something to these charities. So if you go to that next page, Income Secure Act 2.0, which is fabulous. So on December 29th of 2022, it kind of enacted and became law. So IRA owners are now able to not only name the third party special needs pooled trust as a beneficiary, but the not-for-profit, qualified not-for-profit as a remainder beneficiary. So it eliminates, you still have that elimination of the stretch because it's a disabled individual that is the exception or a chronically ill individual. It begins the calendar year of 2023. So if it's 2022 and further back, it doesn't qualify. It's January 1st, 2023, this came into play. And it's really only available for third-party trusts. So whether it's a third-party standalone trust or a third-party pooled trust, those are the ones that gain from the benefits here. So again, really important to understand that certain types of charities are the ones that can benefit from this, basically qualified 501c3s. NYSERC is one of those qualified not-for-profit organizations. And I can't reiterate enough, when you're working on your estate plan and you're having these conversations, really make sure you're working with a special needs planning attorney or elder law. They know this world inside and out, and they can make sure that they're working with you as a family and then working with NYSERC and their legal team to make sure that what you're doing is accurate and correct, that we're not going to actually incorrectly name the beneficiary on the designation form for the IRA, and it's not going to happen or not going to occur, and somehow there's going to be a taxable event there. So it's really important to just make sure that the folks that you're working with really understand special needs trust, because there's a lot that goes to that when they're developing the language. Also with the Secure Act 2.0, there's kind of like a push out too. So it increased the required minimum distribution for mom and dad, if they have an IRA in place. So beginning in 2023, I think it was, the minimum age to start taking on their IRA was 72, is now bumped to 73. And then in 2033, which I'm probably still going to be working, it bumps out to the age of 75. So that doesn't affect the actual when they pass, because that'll immediately start paying out to the special needs pool trust. But just to keep it in mind too, there's a couple of other changes in Secure Act 2.0 when you're talking about IRAs for mom and dad when they're in payout mode, as we call it, which means they've hit the age where the IRS says you have to start taking distributions from your IRA. So really important change. Now you can name a charity, which is huge, I think, because I think a lot of parents and a lot of conversations that I've had with, especially in the pooled special needs trust space, is mom and dad really want to leave a little something to the organization that helped them manage their child's benefits and get them everything that they possibly could, provide all this guidance and support. And just, I think it's super important that mom and dad have that ability to do that now without being penalized. So now they could take one of their largest assets, get it into a shelter for their disabled child, to have NYSERC manage that and pay that out appropriately to that child during their not to the child, but to the vendors or whoever they need during their lifetime, and then stretch that that asset out as long as possible. So that's really, like, those are the two biggest things with the Secure Act 2.0, is the ability to pay out to a charity, and then it really specifically that pooled special needs third party trust. So with that, I think we're good.
Wonderful. Thank you, Cindy, so
You're
much.
welcome.
Again, this just really stresses the importance of working with a knowledgeable professional when you're considering how to leave assets to your children. There are tax considerations. There are all sorts of things when you're navigating these rules that, as you can see, are changing quite regularly. So you really want to be working with professionals who are aware of these changes, who are on top of these changes. It is so essential to helping you effectively plan for your loved one's future. So with that, I know KeyBank, I know you have a little bit of an overview here, Cindy, if you want to give a little bit of background on KeyBank and just kind of your role and how you work with NYSERC.
Yeah, absolutely. So, and thank you, Sarah. So for those of you that don't know KeyBank, we actually are the 11th largest commercial bank in the country. So we actually cover, when you look at the top of the United States, we kind of go from Maine and scoop all the way across out to Alaska. We actually have branches, we call them bricks and mortar, in 31 states. We have about 3.5 million clients, and we have about 17,000 employees. So I have been with Key for 30 years. I started off as a really young kid. Basically, I was a trust officer, and what I did was I worked and managed individual special needs trusts, and I work with not-for-profits and families on the estate planning side. So I've been in this world for almost 3 decades. It doesn't feel like that. It feels like yesterday, but I know, right? And working with families and helping them through managing special needs trust, helping with their kids. And then I had the ability to partner with NYSERC for, oh my gosh, I think it's 7 or 8 years now that we've been working together. And just to come to the understanding of like what they really do on a day-to-day basis is amazing. So I partner with them. Yes, we manage the assets, and then we actually handle a lot of the tough administrative work behind the scenes, so that they can spend more time with you as families and helping you guide and navigate this system of Medicaid and SSI and SSDI, because it's overwhelming at times for parents when they're first starting out. They are such a huge resource, and they are an amazing advocate. And when I talk to estate planning attorneys, because I didn't really know this like 30 years ago, when you think about it, when families want to start, when they're looking at working on their estate plan and they want to create a special needs trust, the estate planning community, when I've been speaking to them, I'm like, you really need to consider a pooled special needs trust like NYSERC, because you already have professionals in place. Everything is there, and it's way more convenient to have mom and dad's estate go directly and fund a pooled special needs trust for their child instead of a standalone, because there's a lot of large financial institutions that will not take standalone as special needs trust unless they're like $5 million or more. That's a lot of money, and the average special needs trust it's not that big. It's not 5 million. So these organizations are already in place. NYSERC is there with their professionals, and they absolutely do an amazing job every day on helping families navigate this world, and get the right things done and get the maximum amount of benefits that they can for the children. So I'm really happy to partner with Sarah and the team at NYSERC, because I see the good that they do every day.
Yeah, we are too. The feeling is certainly mutual. And again, this marriage between a nonprofit service provider and giving us the ability to have that hands-on day-to-day support with the beneficiary, getting to know them. We have the understanding of their government benefits, their living situation, and how distributions from the trust will affect their benefits. This allows us to really focus on that portion where KeyBank is really managing the financial aspects. So it really is quite a wonderful partnership that we've developed over the years, and we certainly appreciate it as well. And KeyBank is also, a trustee for a number of other pool trusts throughout the state and around the country. So they really are experts in what they do. So before we jump into questions, we do just want to remind everybody that our next webinar will be in April. There's a slight scheduling change for next month. We did have a little bit of a conflict with our normal third Thursday of the month. So this training will be on Tuesday, April 25th from 9:30 to 10:30. So still our 1 hour presentation, but slightly earlier in the morning. And we're going to be focusing on how to preserve benefits for people with disabilities who are working, who have the opportunity to work, or who want to work. We're going to be talking about how can we help them protect money so that they can continue to work, get that purpose, and have a meaningful job to go to each day, and not have fear of losing these vital benefits that they need in order to support their daily living needs. So we do encourage you guys. We'll send the slides out. There's a link to register here. There will also be a link to register on our website within the next week or so. So we do encourage you guys to join us next month. And with that, we'll open up. Nina, if you want to let us know what questions we have.
Yes, we have quite a few for both of you.
Good.
Can you amend the remainder beneficiaries of the joinder agreement at the death of the trust beneficiary?
No, you will not be, well, at least in our program. And again, this is obviously potentially different in different programs, but upon the death of the beneficiary, the trust account closes and any sort of arrangements are locked in, right? And it's also going to be upon the death of the donor, depending on, how that trust is funded. Really when the donor dies is when those residual beneficiaries lock in, because we're not going to make changes to what they had set out in their estate plan, right? So that is important to keep in mind. We have a form that it's very easy to fill out to make changes as you need to during the donor's lifetime.
If a community Medicaid applicant, 68 years or older, has a 401k which is not in payout status, is there a way to put the 401k into payout status so that it can be an exempt resource?
Yes. Yep, there is. And you really need to work with Medicaid. I don't know exactly the intricacies that go into that, but it's a slightly different table than the normal life expectancy table that's used to calculate RMDs. I actually think it makes you take out a little bit more, if I'm recalling correctly, for Medicaid purposes. But yes, you can do that, and you will need to do that in order to exempt that resource if you're applying for Medicaid benefits at that point. Good question.
Can someone who is receiving SSD also receive SSI?
Yes, it's possible that if your SSD, one of those benefits doesn't give you the full maximum amount, you can receive a supplement from the SSI program to get you up to that point. So it is possible for people to be eligible for both of those programs. And if you are receiving any amount of SSI, you will be subject to that $2,000 resource limit, even if it's just a very small amount.
So to clarify, I know that an S&T can be named in a will, but are you saying that a parent, for example, can set up a third-party pool trust during a parent's lifetime or an ABLE account and then name the pool trust or ABLE as a beneficiary of the estate?
Yes. Yep.
It's a beautiful thing.
It's really essential for any parent that has a child that may need these benefits or has these benefits. If you do not do that, you are leaving that money to them directly. And as we've spoken about throughout today's discussion, there's a number of advantages that you lose by doing that.
Can you define what Medicaid payback means in regards to an ABLE account?
So as far as the ABLE account, so I'll define Medicaid payback first, and then we'll talk about how it works for an ABLE account. So Medicaid payback is simply a provision in the trust that states that upon the death of the beneficiary of this trust and or ABLE account, any remaining funds are subject to repayment to the states. And it's important, the states, plural, whatever states, not just the state you may be living in when you die, but any states that you received Medicaid services throughout your lifetime. Now, not every single Medicaid benefit accrues a lien. So it's important to keep that in mind. This is a specific type of Medicaid. But essentially, Medicaid is keeping track of the money they're spending on you throughout your lifetime. And when you die, if there's money in a trust, they're going to want to recoup payment for the service they've provided to you during your lifetime. So with a special needs trust, it's generally, you're going to pay back Medicaid up to the amount of your outstanding lien. So whatever your Medicaid lien is. So in NYSERC's case, if we have a standalone trust, we contact Medicaid, find out what the lien is. We need to then look at what we have left in the trust to consider paying that off in full or paying that off, and then what we have left to distribute to other remainder or residual beneficiaries. For an ABLE account, it's similar, same rule, pay back to Medicaid up to the amount of the lien for the period that you had the ABLE account open. I think it is very specific to that, and I would certainly encourage you to speak with an ABLE program directly about exactly that rule, but it is going to be for the period of time that the ABLE account was opened, as opposed to the entire life of the beneficiary.
Is there an age limit to an ABLE account, and is an ABLE account similar to a debit card?
There is an age of eligibility for an ABLE account. So right now, you had to have a disability prior to age 26. That doesn't mean it had to be documented. It means that you had to have a disability at that point, and you're going to have to just, provide some proof to justify that. Right now, the age is 26. As long as you are disabled prior to age 26, you'd be eligible to use a pool trust. There's no maximum age. So again, as long as it was before 26, and that's the rule right now. And an ABLE account is different from an SNT in that you have, or the account holder has direct access to that account and is responsible for managing that money, keeping track of how that money is being used, and they are responsible for reporting to various agencies to justify that payments out of an ABLE account were made for qualified disability expenses. So it is kind of like a checking account in that it is a bank account that you have direct access to, and you can get a debit card. Oftentimes they'll work with like a TrueLink card or some sort of restricted debit card so that you can specify certain things that it could be used for. That can be helpful. But yes, that person does have direct access to that money and can generally take money out of the account either using a debit card or something like a TrueLink card. Again, there's advantages to that. It gives you some flexibility. Some of the ways that NYSERC uses an ABLE account is we may put some funds into an ABLE account to allow someone to have a budget for gas, so that when they go to the gas station, they don't, you can't fill out a request form and send it to the trust and ask them to pay for gas while you're standing at the pump. Giving them that money in an ABLE account can give them that ability to go out and make purchases of gas and directly from an account that they have a card for. So that can be very beneficial for someone that can manage that account on their own. But if that individual is not good with finances or could easily be susceptible to someone taking advantage of them, they do have direct access to that money. And so it's not quite as protected as it would be if you put the funds into a special needs trust. You're also foregoing the benefit of no Medicaid payback if you're putting your own money into that ABLE account, which is, again, like I mentioned earlier, why you want to be sure that whatever funds you put in of your own will be spent during your loved one's lifetime.
If you have a special needs trust, does the language have to be specific about leaving a retirement account to the trust?
If you already, if you have a special needs trust, I wonder if they're talking about if you have a standalone special needs trust, so you have to be specific. Actually, it's the flip flop of that. It's like the IRA beneficiary designation form that would have to spell out the beneficiary is my, Joe Smith third party special needs trust. So it's the flip flop version of that.
Right. We actually had a situation come up where the individual sent us the beneficiary form and had still named their child, put their child's contact information on that form. If they're choosing a program like ours, we have the language, we can provide it to you. It's the third party community trust for the benefit of Joe Smith. Right. So you want to just be sure that that's the name of the person. They're going to ask for social security number. We're going to want to provide the EIN number for the trust. And then we're going to want to provide the contact information for the trust. Because when it comes time to distribute those assets, you want to ensure that the trust is contacted and made aware that it's time for the trust to start receiving those assets.
Do Roth IRAs benefit also from the stretched beneficiaries?
So Roth IRAs are already taxable. There is no required minimum distribution on them. So literally they are an asset of mom and dad to disperse as they want. So there's no calculation there to do. So it's different from that of a traditional IRA, to which we're rolling into an inherited IRA and then naming the third party trust as a beneficiary. So different.
Right. With the Roth IRA, the advantage of that is you're paying the taxes up front when you're making those contributions. And so there isn't that tax penalty later, which is what eliminates the need for the type of planning we're doing with an IRA or 401k.
Regarding retirement accounts as exempt assets for Medicaid, does the account have to be in mandatory payment status, i.e., the account owner have to be over the age of 72 or whatever the current age is to take the RMDs?
Right. So no, they don't have to be over the age of whatever their current age is. I think it is 72 right now. And as Cindy mentioned, next year it's going to 73. And then in 2033, it'll be 75. No, you are not required to be that age in order to start taking the money out. So going back to the example we spoke about earlier, the person that's 68, not taking their minimum distributions just yet, they can put it in what we call payout status. You have to work with Medicaid. Generally, you're going to work with a legal professional to figure out how much you need to be taking out each month in order to exempt that asset for Medicaid purposes.
What is the minimum amount of money to put in order to participate in this program for my disabled child?
So for our trust programs, oops, sorry. Give me a second. I'm just going to go back to this slide. If I can get the Zoom thing to get out of my way. The minimum opening deposit for our two trust programs, if you have a child without an intellectual or developmental disability, the minimum opening is $10,000. And again, that can be at your death. It does not have to be during your lifetime. If your child has an intellectual or developmental disability and wants to utilize the unrestricted fund program, that's a minimum opening deposit of $25,000. And again, there are other programs. If you choose to do a standalone special needs trust and you want to choose a family member to serve as the trustee, there's generally no minimum requirement of what needs to go into the trust unless that family member is charging for their services. If you're working with a professional, like a financial institution or a corporate fiduciary, as Cindy mentioned earlier, some of those banks won't work with anyone with less than $1 million or even up to $5 million. So that's going to vary depending on what program exactly you're interested in. But for NYSARC, it's either $10,000 or $25,000 if your child has an intellectual or developmental disability.
What if the beneficiary has an irrevocable trust? Can the IRS be named in that trust?
I'm thinking they meant IRA, not IRS.
Yeah.
And if it's a regular irrevocable trust and not a special needs irrevocable trust, this does not apply to that. It has to be a special needs trust in order to eliminate it, because it's the disabled individual that is the exception to the rule was the Secure Act. So when you're working with a irrevocable trust that mom and dad established, it is not a special needs trust. So it doesn't work in that capacity, unfortunately.
So for an IRA, parent can name third-party trust as beneficiary. Is it just for RMDs or for all of the IRA?
So what happens is that it's the entire IRA. It's then the special needs trust's name as the beneficiary, and that entire IRA comes out of mom and dad's name, mom's name or dad's name, rolls into what we call an inherited IRA in the name of the trust. So it's the whole IRA. But again, if on the beneficiary designation form, if they name the special needs trust as a 50% recipient and maybe another sibling as the other 50%, then it would be 50% of the IRA that rolls out. So it depends on what they're doing on the beneficiary designation form. That form is key. And that form too, I should have said it before, I highly recommend that mom and dad, you look at your IRAs every year and make sure that the beneficiary designation form is as you want it. So there may be changes throughout your lifetime and events that happen, and you don't even think to go back and look at that part of the IRA form. Very important to review.
Yeah, and that was a good explanation and overview. Thank you so much, Cindy. And going back to the question, it's the RMDs until that, for the time that child is alive and distributing funds from that account. It could be the entire IRA if they're able to utilize it all the way throughout their lifetime. It may be, the portion that they're able to utilize. So it could be a little bit of both.
Can an IRA be left into a pooled S&T without the asset being needed to be taken out of the IRA umbrella right away?
Right. So that's exactly what we're speaking about. You're not talking about taking the assets out of the IRA umbrella. It's rolling into the inherited IRA, and then whatever distributions that are required, and these distributions will be calculated based on the life expectancy of the person with a disability. Those are generally taken out on an annual basis, and each year that distribution goes into the special needs trust for their benefit. And when it goes into the special needs trust, there's then no requirement for them to spend that money, right? And now we have it in another vehicle where it can be invested and stretched throughout their lifetime as well.
My niece inherited her father's co-op apartment. There was no will or S&T in place. I am now administrator and wish to plan for her future. Do the proceeds from the co-op have to go into a first-party trust? And for my own estate, I would set up a third party?
Yeah, it's probably very likely that at this point, since that asset has been given to your niece, that she's now the owner of that. And so any proceeds from the sale of that, she can put into her own special needs trust. And if you're looking to plan for the future of your niece and you have assets that you would like to leave to your loved one or to your niece, you want to do that with a third-party special needs trust. Again, if you don't do that, she'll still have that option of putting it into her own first-party trust. She'll have to do that within a month of getting that money to avoid any sort of interruption in her benefits. Receiving that money in that month might be treated as income to her when she gets that money, depending on how it's transferred. So there are definitely, it's much more advantageous for you to set up a third-party trust in anticipation of that so that it can pass to her in a vehicle that it will not interrupt her benefits.
Can you name a pooled trust as the beneficiary of a life insurance policy? And what if a pooled trust is named as a beneficiary of an estate, but the estate ends up holding real property?
Sure. So yes, you can name a pooled trust as the beneficiary of a life insurance policy. And yes, you can include a pooled trust in someone's estate to have the proceeds from that portion of the estate the disabled beneficiary is going to receive can go into a special needs trust, a pooled special needs trust. If it ends up holding real property, Traditionally, they are going to need to sell that property or give up their ownership in that property, receive some compensation for that, and then those funds can transfer into the trust. It's also important to keep in mind, sometimes you're not going to sell the home. Sometimes the home may be inherited by that person for them to live in. And you can have a primary residence. So it's not necessarily that they are going to have to sell that home, but that is just mostly, most often how traditionally, that goes. But if you are in a situation, where you're closing out an estate and there's real property involved and you have a pooled trust that's named as the beneficiary, contact us. We can certainly speak with you about that specific situation and talk through what options the beneficiary has.
Does KeyBank act as trustee for an individual third-party trust?
So we do. So we work with NYSERC in conjunction as co-fiduciary on the third-party pool trust and then third-party standalones.
What are the income tax consequences of having the RMD paid to the SNT that is an accumulation trust, i.e. RMD not distributed, but stays in the trust?
So it's income into the trust. So it's just, that's why it's the beauty of having the RMD slowly be calculated out and stretched out, because it's smaller amounts that are being pushed out of the IRA and into the third-party accumulation trust. So it just becomes an asset of that third party and taxed at the trust level.
Is there a penalty for moving funds from a UGMA to an ABLE account or an SNT trust?
I just don't know the answer to that. So I don't want to give you any misinformation. I believe also it may be dependent on particularly how you have your account set up. So if you have one of those accounts, we would encourage you to contact the institution you set it up with, and they should be able to give you more information about any sort of penalties of moving that money around. I don't know if Cindy, you know better.
No, I don't, unfortunately. I'd have to do some research on that one.
We have a question about the look back period for long-term care services, if we have an update on that.
Yes. So just for everyone on the call that may not know what the look back period is, in New York State, if you apply for Medicaid to pay for nursing home care, meaning that some point in your life you need to go into a nursing home, the cost of a nursing home can be up to $14,000 a month, depending on where you are in the state. It's a very significant amount of money. And Medicaid is one of the primary payers of long-term care services in our country, and specifically in New York State. If you want Medicaid to help cover the cost of that nursing home care, you need to apply. And when you apply, they're going to look back at your financials for 5 years to see if in that 5-year period, 5 years before you applied to go into the nursing home, you moved any money out of your name in order to become financially eligible for Medicaid. Now, if you moved money out of your name during that period, you could be penalized based on the amount of that transfer, and you'd have to private pay for services for a certain number of months, depending on how much you transferred, before Medicaid will start to pay the nursing home bill. Okay, so we've always had a 5-year look back for nursing home care, at least in my time. We do not, however, have a look back for home care services. If you need home care services and you don't want to go in a nursing home, you want to get the services in the comfort of your own home, you can apply for community-based Medicaid long-term care services, and there's no look back period. I could move money out of my name, I could transfer my money to Cindy this month, and I could be eligible for Medicaid as of April 1st. They might collect 30 days of my bank statements, but they're not going to penalize me for any sort of uncompensated transfers that I made during that time. So that's a great advantage to us in New York State, that you can protect your assets in a crisis situation and apply for Medicaid in the following month without being penalized for those transfers. In 2020, they introduced the potential for a 30-month look back for community Medicaid, meaning that when you go to apply for community Medicaid going forward, they're going to look back 30 months to see, so 2.5 years, to see if you made any transfers to qualify for home care services. That look back has not yet gone into effect. Because of the ongoing pandemic, it continues to be delayed. At this point, the earliest date that they will be able to put that look back into place is April of 2024. And it may even be later. And they still need to get CMS approval. So this is something that's been pending for a while. And we don't have any sort of concrete regulations or information that we can say, this is when it's going to go into effect. But just know that if it does go into effect in the future, it will apply to any transfers that were made after October 1st of 2020. And it is only for applications of home care services or personal care services. So if you're applying for basic Medicaid benefits, there's not going to be a community look back. It's only when you apply for that home care component. And it's also not going to apply to certain waiver programs. So Department of Health has indicated it won't apply to NHTD waiver, TBI waiver, or OPWDD waiver. We hope to have more concrete information about that in the future. So we do encourage you guys to follow us on social media, join our mailing list, because as soon as we have more information, we'll be sure to update everyone on any changes regarding a potential community-based look back.
Do we want to continue with questions? We are over the hour.
How many do we have left, Nina?
Plenty.
Okay, so if we have a lot, I think we're going to close for today, just to be respectful of everybody's time. We're at the end of our hour. We will go through the questions. If we're able to identify who you are, we'll reach out to you, but we do encourage you to contact us. If you have specific questions, if you want to talk through a scenario, we encourage you guys to reach out to us. Our customer service team is available 8:30 to 5, Monday through Friday. We also have a lot of great information and resources on our website. You can watch past webinars, access frequently asked questions that can really help educate you on these programs. Thank you again for joining us today. Thank you, Cindy. We really appreciate you taking the time to be here and help to explain this very complicated Secure Act process and topic. We hope that everyone learned something new. And we do ask that you please take a couple minutes to complete the survey that you'll receive right after we close out the webinar, just giving us some feedback on today's webinar. So thank you all. We look forward to hopefully seeing you in April, again on Tuesday, April 25th, 9:30 to 10:30. All right. Thanks, everybody. Have a great day.
Take care, everybody.